much, Tom and friends. It's always a real personal pleasure and a great privilege to speak at Chautauqua. It's a particular privilege to get to introduce what is becoming a fine and, as President Becker notes, collaborative tradition of a Robert H. Jackson lecture here at Chautauqua each summer on the Supreme Court of the United States. My modest role this afternoon is to say a word about Jackson, a word about the Supreme Court, and a word about this year's Jackson lecturer. Robert Jackson, as Tom Becker noted, is a local product, but he went from this soil and this region on a very high trajectory. It included a 20-year career in private law practice and then nearly a decade in government service before he went to Nuremberg. His government service in Washington under President Franklin Roosevelt included a stint in the Treasury Department and then service up through a ladder of positions in the Justice Department, culminating in service for 2+ years as the Solicitor General of the United States and then as the Attorney General of the United States before Jackson was appointed to the Supreme Court in 1941. In 1945, he took a 1-year leave from the court on appointment from President Truman to serve as the architect of and then as the chief American prosecutor at the International Military Tribunal, before which the senior Nazi war criminals were prosecuted, and a proceeding that built the historical record that allows us to know the crimes, the conduct, the Holocaust that was Nazism. Jackson returned to the Supreme Court after Nuremberg and lived and served for 8 more years. He is revered across the legal profession, in law studies, in American history, and internationally for his life and his contributions and his sparkling writing and advocacy. And that significance is, frankly, a growing industry. I, as a biographer, play a role in that and get to benefit from it. And Chautauqua Institution, as one of his core roots and formative locales and identities, is a big part of that. Part 2, the Supreme Court of the United States. Of course, from Article 3 of our Constitution, across the centuries of our country's existence, and in the year that is every year, and in the lives that is every person, the Supreme Court is enormously significant. The Supreme Court, particularly on its calendar, beginning a term in October and rising for a summer recess in June, situates itself very conveniently for the Chautauqua Institution program, and for a venue like this as an opportunity to focus on the court. It's probably not planned exactly that way, but it works out quite beautifully. Here you are, here we are, and here we have lecturers like the one I'm about to introduce to help us focus on the court at an annual moment to take stock and study where we are. Of course, this year particularly, the Supreme Court is on our minds, and literally this day on our eyes, as the Senate began its hearings on the confirmation of President Obama's nomination of Judge Sonia Sotomayor to fill the vacancy created by Justice David Souter's retirement. So we have the end of a term and a Sotomayor summer, or a hearing that will take less than a summer, that focuses us on the Supreme Court. Part 3, the Jackson Lecture at Chautauqua Institution on the Supreme Court of the United States. This tradition began in 2005. And every year, frankly, it has grown in greatness, the greatness of the audience, the interest, the questions, the scrutiny, the reflection, and the stature of the lecturers who stand on each other's shoulders and are building a fine tradition here. Professor Jeffrey Stone of the University of Chicago Law School inaugurated this lecture in 2005. He was followed in 2006 by Seth Waxman, a former Solicitor General of the United States under President Clinton, now an attorney practicing with the national and international law firm of Wilmer Hale. He was followed by Linda Greenhouse in 2007, then the New York Times Supreme Court correspondent and now a professor at Yale Law School. And she was followed last year by Jeffrey Toobin of the New Yorker magazine and CNN. Those 4 lecturers are now succeeded this year by Paul Clement. Paul Clement is a native of my native Wisconsin, so he's my brother from the soil. He has a distinguished resume, a life of achievements, honors degrees from Georgetown University, from Cambridge University, from Harvard Law School. He then served as a law clerk, first to Judge Lawrence Silberman, the distinguished judge of the D.C. Circuit Court of Appeals, and then to Supreme Court Justice Antonin Scalia. Paul's career then climbed higher. He had a stint in private practice, service as a counsel on a United States Senate committee, and then a stint in the U.S. Department of Justice, first as a member in the Office of the Solicitor General of the United States as a deputy, and then from 2005 until 2008, he was the Solicitor General of the United States. In that role, in that office, he was part of representing the United States, both the executive branch and the statutes, and behind them, all of us in the appellate courts of our country, and culminating in the top of the pyramid at the Supreme Court of the United States. Paul has argued before the Supreme Court, I believe, 49 times. And he has a couple of cases coming this fall, and he soon will pass Justice Jackson's number, which is in the 50s. He is a sterling advocate. You'll see his forensic skills in a moment. He is a legal talent who is appreciated across all spectrums. His stewardship in the Department of Justice as Solicitor General is regarded across all spectrums as one of the fine pieces of public service in our country's recent history. I'll note that Solicitor Generals have a tradition here at Chautauqua. Paul becomes, by my count, the 5th former or future Solicitor General to speak from a Chautauqua audience to a Chautauqua, from a Chautauqua platform to a Chautauqua audience. Robert Jackson, of course, was one. He was SG 1938 through 1940. Thurgood Marshall in 1957 was still not yet the Solicitor General, which he became in the 1960s, but he spoke at Chautauqua. Stanley Reed, who was Franklin Roosevelt's Solicitor General before Jackson, spoke at Chautauqua in 1937. That was the summer of the court packing plan. And as I mentioned, Seth Waxman in 2006 spoke here as a Jackson lecturer in this series. I'll note one final pairing that I think makes this a wonderful opportunity and illustrates something about the legal profession, the Supreme Court, Solicitors General, and the rule of law. You may recall, if you were here, that Mr. Waxman spoke about the run of Supreme Court cases in the War on Terror when he was here in 2006. And other aspects of Supreme Court work were also his topic. But in a sense, he previewed then the argument that he would give later that year in a Guantanamo case involving federal statutory and constitutional rights to habeas corpus review for the detainees imprisoned by our government at Guantanamo. That case was called Boumediene versus United States. And it was decided the following June, and Mr. Waxman and his client were the prevailing parties in that case by a vote of 5-4. I mean this not at all to poke. Paul Clement was the losing attorney in that case. Boumediene versus the United States was Seth Waxman as a private pro bono attorney representing Boumediene against the United States. And Paul Clement was our lawyer. He represented the United States. He took the path of law, of public responsibility, of tradition, precedent, and principled argument to the right place. He defended in proper terms the position of the executive branch, to which he had been confirmed by the Senate, in which office he held at that time. And he made arguments that I encourage you to listen to on Foyer.com, where you can hear his Supreme Court advocacy generally, and he lost. And something like that is a piece of the greatness of the United States. We are a nation of the rule of law. We are a nation of the Constitution. We are a nation of public courts and legal accountability. And it turns on the commitment that we as citizens and our greatest advocates as lawyers have to that system. Robert Jackson was a piece of it. The Supreme Court is an enormous piece of it. This lecture considers and celebrates a piece of it, and Paul Clement is a very important piece of it. And so it's a privilege to welcome him today. Thanks.
Well, thank you, John, for that wonderful introduction. It is wonderful to be here. I have to say this is just a very special place, so I'm very happy to be with you.